Hey everybody, welcome back to another episode of Hail State Debate. It is March/April of 2023, and that means it's time for the last regular season topic of the year in Lincoln Douglas debate. And we have an interesting one, at least for me personally an interesting one, and that is resolve the justices of the Supreme Court of the United States ought to be term limited. We obviously want this to be useful to you, so if it is, maybe like, maybe subscribe, maybe tell a friend. As always, the sources and the timestamps, as well as our team's social media, will be in the notes below. And as is frequently the case with me is Mia Robertson. Mia, how you doing?
I'm doing pretty well. I'm excited for this.
And you are in luck because we're not just like a debate coach and a very good debater. We are also people who have an actual intense interest in this subject because it is something that we both actually do for a living. I am a lawyer. Mia is an aspiring proto-lawyer, but she actually works for a judge on a court. So this is not your regular like debate channel stuff where we're just talking about something we don't know. This is something that we actually find interesting. So there's a lot to cover. So just kind of jump in with some initial thoughts like we always do. Mia, you want to go first?
Sure, I'll go first. I do think this is a pretty straightforward, solid topic. I do have one problem in that I think it leaves basically no room for creativity. I think it's an interesting topic, but I think it's interesting for just a couple of reasons, and I can't really think of a lot of different unique arguments that you might be seeing. So my fear is that you'll go into rounds and see basically the exact same arguments over and over and over that lead to all of the exact same impacts, which isn't necessarily a bad thing. I mean, obviously it means that you get to get really well versed on a couple of topics, which is good if you're a debater, but it's going to be difficult to give your judges a good time and be creative within reason.
The way I had it on mine is very similar to that. The first thing I wrote was, it is a confined and manageable topic. And so I think if this were like the resolution for like the first resolution of the year for PF for like 1 month, if they did it for 1 month, which they don't anymore, but if that were the case, I think it'd be perfect. For the last resolution of the year, for like national qualifiers, state championships, TOC, a bunch of big tournaments, and going for 2 months on it, I tend to agree with Mia. I think maybe the impacts are a little bit limited and the rounds may get a little bit stale over time. But that's just one of those meta problems that good debaters have to cope with and have to deal with. You have to make the core argument stronger. You have to be more prepared to defend sort of the details and the nuances and the sources. The other thing I had on this topic, though, is that you can't just beat opponents over the head with numbers. You have to tell a story, right? It's very difficult, with a handful of small exceptions that we'll note in the video, to come at this with like sort of pure empirics. We're going to look at statistics. We're going to look at outcomes. There are even theoretical arguments that we'll talk about later that like outcomes from the court don't matter, because there are philosophies about how the court's supposed to function that it's not the court's job to produce outcomes. It's its job to just accurately apply the law. So it's very difficult to sort of just beat people over the head with quantifiable impacts like money and lives and things like that, which means you have to give a narrative and you have to explain, right, in the course of your case and in your rebuttals, what is it that the court is actually supposed to be doing? What is the legitimate function of the court, and why are we meeting that, and why are they not doing that? So for us as lawyer/proto-lawyer, very interesting, a lot of fun. For you as a debater, who maybe does not care so much about these things in your day-to-day life, maybe it is not such a great topic, but either way, it's what you've got to debate. So with that, we will jump right in and do our usual, which is starting with definitions and framing, then values and criteria, then AF arguments, then neg arguments, and then final thoughts.
Let's jump right into some definitions and framing. Now, I think we can both agree this is probably one of the simplest resolutions we've seen in terms of definitions in LD in a very, very long time, or probably in the entire time we've done this channel. Right. You really only have 3 terms: the justices of the Supreme Court of the United States, ought, and term limited. So because it's a pretty straightforward resolution, we'll just briefly run through some of those definitions, and then we can turn to some more in-depth background on the Supreme Court and different proposals for term limits. So first, the justices of the Supreme Court of the United States. This is really obvious. This is obviously just referring to the individual members of the U.S. Supreme Court, of whom there are currently 9. Justice is the term that we use for judges sitting on that highest court in any jurisdiction, and the Supreme Court is, of course, the highest court, or the court of last resort, in the United States federal judicial system.
So that brings us to ought. Now, ought is also pretty straightforward. Webster defines it as expressing obligation or advisability. Collins Dictionary defines it as meaning that something is necessary or would be a good thing to do. So generally ought just means that we should do something. The only possible complication I can think of with ought is that occasionally you see this argument in Lincoln-Douglas debate that ought implies a moral obligation, and because we're talking about a moral obligation, the AF doesn't have to explain how the resolution will happen or like provide a plan or anything like that. I've said this before on this channel, and I'll say it again. I don't think that this matters very much here for two specific reasons. First, it's just not a very strong argument to begin with. So the idea that the morality or the desirability of an action is separate from its practical feasibility, in my view, is just not true. So a doctor might have a general moral obligation to treat the wounded, but if a particular doctor does not have the expertise to provide the necessary treatment and might make the situation worse, then the moral duty obviously changes. So the practical feasibility does affect it. But second, on this particular topic, there's probably not going to be that much debating about like how we would impose term limits. It's not like a major policy initiative like Medicare for all or high-speed rail where we're going to have to find trillions of dollars in funding. We're going to have to set up new agencies and things like that. It's basically a rule change, right? Now, it might be a very important rule change, and we'll talk about in a minute. It might be a rule change that requires a constitutional amendment, but it's still a rule change. A law gets passed or an amendment gets enacted, and the rule just is what it is. So probably not a whole lot to debate about on implementation, and hopefully that means you won't see a lot of people sort of trying tricks about what ought means or who the actor is and things like that.
So the final term is term limited.
Right.
It's also a pretty straightforward term. There's a little bit of room for interpretation or ambiguity, but as a practical matter, we don't really think there will be that much disagreement here. So we can look to just straightforward dictionary definitions like Webster Dictionary, which defines a term limit as a specified number of terms that a person in office is allowed to serve. Now this is pretty clear, straightforward. It's a definition that works in elected offices like Congress, but it doesn't really address the question of how long the terms are. You could say you're limiting a person to one term on the court, but if that term is 50 years, you're not really having any impact because nobody's going to serve that long anyway, and it basically amounts to a lifetime appointment. So, that's not very helpful in this context. Another slightly better definition is one from the Michigan State University Institute for Public Policy and Social Research. They're writing in 2017, and they say term limits place a limit on the amount of time a person can serve in an office. Now, this does better at addressing that issue of limiting the total time that justices can actually serve on the court. So obviously, that's a bit more helpful for you. But obviously, there's still that big looming question, how many years are we actually talking about? Now, you may decide that you want to provide a definite answer to that question in your case by pointing to a specific proposal. So for example, and as we'll talk about in just a second, there's a strong consensus among experts that one 18-year term on the court is the best proposal out there. So you may just want to define term limits by citing that particular proposal or just upfront saying, this is the limit I'm advocating for whenever I say term limited.
Or alternatively, and we're going to talk about this a little bit more throughout the video, you might want to preserve some strategic ambiguity and maybe not explicitly commit to a single particular proposal or plan as like a definition or literally read it in your case. It kind of depends on your debating style, right? Like what kind of debater you are. It also depends on what circuit you're in. If you're in a circuit that hates plans, don't read a plan. If you're in a circuit that expects plans, well, you might need to say, okay, we're signing on to this 18-year plan from so-and-so legislation. But at any rate, to sort of understand how these definitional choices play out in practice, we need to shift gears and talk a little bit about background information on the Supreme Court, lifetime appointments in the status quo, as well as the proposals to change that.
So lifetime appointments are based on Article 3, Section 1 of the Constitution, which reads, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office." So the really important terms there are during good behavior. And that term means that just once you're appointed, you retain your office until you retire, die, or get removed for good cause. As the National Constitution Center explains, the language about holding offices during good behavior has basically been interpreted to mean that the only way a federal judge can be removed from their office is if the House of Representatives impeaches them and the Senate convicts them of treason, bribery, or other high crimes and misdemeanors. And they basically go on to say that any judge who doesn't commit a crime or something that's equally bad has lifetime tenure and will stay in office until they die or voluntarily step down.
So in practice, what this means is that the typical Supreme Court justice spends a long time on the court, and it's getting dramatically longer. The President's Commission on the Supreme Court in 2021 summed it up this way. We're going to pop it up on the screen. You can see it. The consequences of life tenure for our constitutional system have changed over time as the average length of justices' terms has expanded. Lifespans have lengthened, and modern justices may increasingly delay retirement. Up until the 1960s, the average term of service was around 15 years. By contrast, the average tenure of the justices who have left the court since 1970 has been roughly 26 years. By the way, real quick, the President's Commission draft report that we just cited is a fantastic source from multiple highly credible scholars that outlines a lot of arguments on both sides of the debate. It talks about constitutional questions and so on. It's about 30 pages long, and of course it's linked below, so you should read the whole thing. Not just cut a few cards, not just glance over it. I know people are allergic to actually reading things. My son does Lincoln Douglas debate. He hates reading things. He's probably watching this. Maybe he'll drop a comment and say that I'm wrong, but the truth is they do, but you actually need to read it. It's 30 pages long, and it'll give you a great overview of what's going on. But the reasons for this longer tenure are, one, just longer lifespans, right? When Article 3 was written, if you lived to say 60 years old, you'd had a really good run. So today, though, it's very common for people who have good access to health care, which of course Supreme Court justices are going to have, to live into their 80s or even to 90.
The second reason is that presidents are really strategic about appointing relatively young justices to the court to maximize their impact.
Right.
And you might think, well, if people are living to 90, it's no problem if we appoint a 65-year-old to the court, but obviously nobody does that, right? Because you want your nominee, who probably has a similar ideological lean to you, to be on the court for decades and make rules in that position for decades. So when he was appointed, for example, Clarence Thomas was 43, John Roberts was 50, Amy Coney Barrett was 48, Ketanji Brown Jackson was 52. So they're not super young in absolute terms, but once you're out of law school, I mean, this is a job. You're doing well into your 80s. You can do it for a very long time. So we're talking about very long tenure. And if you think decades-long tenure is a problem, that problem is likely going to get much worse. David Fishbaum, writing in the Harvard Business Review in 2018, predicts that based upon just appointment age and life expectancy, the average tenure on the Supreme Court will rise to 35 years over the next century.
And like we said, there's nothing you can do about this in the status quo to reduce that tenure, because Article 3 of the Constitution says they, quote, serve during good behavior, which effectively means as long as you're not impeached for misconduct, you're going to keep the office until you retire or die. In other words, the Constitution seems to prohibit time limitations for the service of Supreme Court justices as well as judges on lower federal courts. So what this means is that for the AP, you are probably going to have to advocate for an amendment to the Constitution to limit justices' terms. You probably cannot do it just by having Congress pass a law, because it's right there in the Constitution. But I say probably because there are some legislative proposals that try to sort of tiptoe around the language of Article 3, Section 1 and impose Supreme Court term limits purely via legislation from Congress.
So that makes now probably a good time to shift gears and talk about what those proposals for term limits might actually look like. So the most common proposal for Supreme Court term limits seems to be an 18-year term with no possibility of renewal, with each seat being filled in a 2-year staggered basis. So every 2 years a term would end and a new nominee would be appointed, giving each president 2 nominees per term. Maggie Jo Buchanan of the Center for American Progress sums it up pretty well in 2020. She says this: while there are a range of potential term limit proposals, there are some general principles that have rightly achieved broad support. An 18-year non-renewable term is overwhelmingly the most common proposal, although Chief Justice Roberts once expressed support for a 15-year term. Justice Breyer argued that an 18-year term period would give justices enough time to fully learn the job and develop jurisprudence, a position bolstered by the fact that many justices have voluntarily retired after a similar period of service on the court. Now, you see this popularity expressed by the fact that we have this introduced by members of Congress in several different proposals. So, for example, the Supreme Court Term Limits Act was introduced in 2021 by various Democratic members of Congress. Additionally, there's a very similar piece of legislation called the Supreme Court Term Act, introduced by Democrats in 2022, which would also create a single non-renewable 18-year term.
So that's a lot to take in, I know. There's a lot of background on this. Hopefully we covered it efficiently, but there are a few other details that are probably worth discussing before we start moving on to things like values and criterion. So first, Why 18 years specifically? It's worth understanding this, right? It's pretty clear that the consensus around an 18-year term is mainly a function of the fact that we have 9 justices on the Supreme Court. So if you want to do these regular rolling appointments with each president getting the same number, you're going to have to use a number that is a multiple of 9. So a 2-year interval and an 18-year term seems like arguably the best compromise between, on the one hand, not having like constant Supreme Court confirmations every single year, but on the other hand, not having a term that's so long, like say 27 years, that it effectively really does not matter. So another question, though, is what are some alternatives in terms of term limits to these 18-year terms? Well, one would be age limitations, which are actually extremely common around the world. So this comes from Tom Ginsberg, a law professor at the University of Chicago, comparing U.S. systems to international systems in terms of term limits. I'm not going to read all of this, just going to pop it up on the screen, but you can see what he's saying here is that essentially every major developed country that he's looking at here has some form of term limits, and a lot of them use age limits as sort of a de facto term limit. So you can see the United Kingdom has an age of 70, Canada is 75. Former U.S. territories whose constitutions were heavily influenced by ours do the same thing. So for example, the Philippines has it at 70. And also, as we'll talk about later, he points out the fact that U.S. states follow similar models in terms of having either term limits between 6 and 14 years or a retirement age of around 70. So it's a very common thing both in the United States at the state level and also globally in other countries.
Should you maybe consider advocating for that age limit? Well, there are a couple of questions to answer. First, does an age limit actually meet the definition of a term limit such that it would be topical? I would say probably yes. Most of the time we don't call age limits term limits, but if you use the definition that we gave earlier from Michigan State, it says that a term limit is just a limit on the amount of time a person can serve in office. So an age limit is obviously that. The limit would be different for different people depending on when they start, obviously, but it absolutely does limit their time. So it's probably topical, although you may get some pushback on that. But second, and probably more importantly, is an age limit actually a good strategy for the AF? And I'd say probably not.
I would say probably not too.
Yeah. First, it carries the specter of age discrimination, which can definitely rub some judges the wrong way. Second, it's really hard to nail down what the right age would be because people's capabilities or people's capacity is just wildly different. There are some 70-year-olds who struggle with basic things, and there are 70-year-olds who function like 40-year-olds. And thirdly, age limits can be circumvented by just appointing younger justices. So if the age limit is 70, you would probably see your first 35-year-old Supreme Court justice pretty soon. And don't laugh, because you absolutely do see 35-year-olds get appointed to lower federal courts right now.
I know, because like people I went to law school with who, frankly, I'm not going to name any names, might not have been the most erudite of law students, managed to get appointed to like federal district courts in their mid-30s. And I was like, how is this happening? Well, it's happening.
All you got to do is be 35.
Absolutely. Be 35, be politically loyal, go to a decent law school, and you get a life tenure. You can do whatever you want. It's great. So, if age limits aren't a great option, what are some other alternatives? Well, as we said earlier, you can certainly look around the world for examples of time limits other than 18 years. So again, looking back to the Ginsberg piece we just cited, he points out that some 27 constitutions have term limits for Supreme Court justices ranging between 5 and 15 years. For example, justices of the Supreme Court of Mexico are appointed for a non-renewable 15-year term. He also points out that other countries have like specialized constitutional courts that aren't their Supreme Court, but they address similar questions to what our Supreme Court does because they answer constitutional questions. And he says of the 88 systems that have these, 40 provide for a term limit for the judges right there in the constitutional text, and all the others have a statutory one. So what you can see here is that there are many options that you can look at around the world if you want to pick a different time than 18 years. You can certainly do that if you want to be creative. Now, they might be a little difficult to square logistically with the current size of the Supreme Court at 9 justices, and presumably if you have a desire to rotate them on and off on a regular basis, it might be a little more difficult to do that. But the bottom line is it can be done. You are not necessarily locked into the 18-year proposal.
What I would not do, though, if I was the AF, is depart from the idea of a single non-renewable term.
Right.
Because if a justice can be reappointed, that creates an obvious major conflict of interest. Assuming you want to keep your job, you're going to have a strong incentive to decide cases based upon what you believe will be politically acceptable to whoever's in office once your term is up, rather than based on what is legally correct. Anyway, if it was me, I would probably default on the AF to defending the consensus 18-year single-term non-renewable proposal because it's workable, it has tremendous support in the literature, it represents a solid compromise, and it doesn't have any obvious glaring weaknesses.
Yeah, I agree with that. There are some places on this resolution where you might get a little cute and creative, and we'll talk about them later, but I just don't see a really obvious, major net benefit alternative to the 18-year proposal. You might not want to read that in your case. In other words, you might want to hold it open and like wait for it in cross-examination, and if you're pressed on it, say, oh, okay, well, if you must know, I advocate for 18 years. But either way, I wouldn't affirmatively depart from it. I think Mia's right on that. So the last question that I have in terms of just like kind of logistical questions is a legislative solution even constitutional? So looking back at the two bills that we've already talked about, the Term Limits Act and the Term Act, you're probably thinking, wait, hold on, didn't you say earlier that this was written right into Article 3 of the Constitution, this idea of life tenure with good behavior? So how could a bill in the legislature impose term limits, a bill in Congress? The Constitution, as we all know from basic civics, Constitution trumps federal statutes, so this would be unconstitutional if the Congress tried to do it. The answer is that these bills try to get around the good behavior clause of Article 3 on sort of a technicality. So with the Term Limits Act, it would let the justices who reach 18 years keep their judicial appointment and keep their salary, but they would just be required to serve on lower courts. They'd get like demoted to, say, the DC Circuit or the 7th Circuit or wherever, right? And with the Term Act, a justice who reached 18 years would be required to take what's called senior status. And taking senior status, I know this because the judge that I clerked for took senior status recently. It means that you keep your office, you keep your pay, but you step back from actively hearing cases. In his case, it was on an appeals court. The Supreme Court would be on the Supreme Court, and you can basically sort of sub in as a substitute, right? You can hear cases occasionally, but you can't be in the regular rotation. You can't be among the 9 people who hear them regularly. So if like a justice or a lower court judge had to recuse themselves, a senior justice could step in and hear the case, but they could not be part of the regular rotation. Sort of like going from being on the bench to being on the bench, if you will forgive a terrible pun that I'm obliged to do once per video. But anyway, I would certainly be aware of these proposals, but I probably wouldn't hang my entire case on them. I wouldn't say like I'm defining term limited as the Term Act or something like that, because for both of these bills, there is a real question as to constitutionality. And if I were on the neg and I heard my opponent commit to them, well, then I would instantly add a constitutionality argument to my refutation that you just don't have to have as the app if you don't commit to them.
Right. More broadly, I personally just wouldn't spend too much time thinking about exactly how, whether by statute or constitutional amendment, term limits would get imposed. Because this is a resolution about whether something should happen, if it's a good idea, not how it will happen or whether it will likely happen. So AF can absolutely say, yes, I'm asking you to vote, use your fiat power as the judge to implement a constitutional amendment to make term limits happen, and that's completely legitimate.
Yeah, I agree with that too. So with that, that is a lot of background. Let's move on next and talk a little bit about values and criteria. Okay, so let's talk a little bit about values and criteria. I will say for me, I think that this section might more accurately be described as just sort of the philosophy behind the resolution rather than like literally looking to values and criteria, but I think understanding the philosophy is important. So in some ways this almost doesn't feel like a regular LD resolution in that, as Mia pointed out, it is so narrow, so specific, and policy oriented. It's frankly more like the topics you saw in PF debate in the first years that it existed. It was a very specific, narrow proposal that anybody who followed the news would be familiar with, and that's good and bad for various reasons that we've talked about. But in terms of deep moral philosophy, you might not find quite as much on a topic like this as you would say on like radicalism versus incrementalism, which is what we had at Nationals last year. But that said, there is at least one very important philosophical question that everybody has to wrestle with on this topic, and that probably will make its way into the framework of cases, at least among debaters who are more conscious and intentional about it. And that question is, what does the Supreme Court really exist to do? What is its true role in government? What is its true role in a just society? And there are two basic answers to that question. One is a more traditional formalistic answer, and the other is a more practical, critical, sort of real talk answer. And it's important that you understand both views as you frame your case and your criterion, because this basic divergence, right, on what does the Supreme Court really do will be a factor in every round, whether you're conscious of it or not, whether you plan for it or not. But if you are conscious of it, you will be able to better better structure your case and better exert control over the round?
So the first view that Brett alludes to is what we would call the legal formalist approach. That's to say that the role of the Supreme Court, and really all courts, is just to apply the law to the facts of that particular case. In other words, under this view, courts simply interpret what the law already says. It's as John Roberts put it in his confirmation hearing, judges are to act like umpires. They just call balls and strikes and do nothing else. And that's, frankly, obviously the view that you get taught in school. The legislature makes the laws, courts interpret the laws, the executive branch enforces the laws. Courts hear cases, some cases get appealed up to the appellate courts or the Supreme Courts. They all just mechanically apply the law according to certain rules, like the Constitution trumps a statute, and so on, to reach the objectively correct outcome. And it's not political or partisan at all. It's not about policy making. It's just these sort of nerdy legal technicians finding out the specific application of rules that were already there all along. And under this view, specifically, the argument would be that term limits are unnecessary at best and harmful at worst, because if all judges are doing is applying the laws and technical rules according to a sort of algorithm they already learned in law school, you would want their work on the court to be as insulated from political influence as humanly possible. And you'd want to let them do this technical, non-political, almost priestly work in an isolated environment as much as you can.
And what this means is you want life tenure under this theory, so that the justices never have to worry about pleasing Congress to say get reappointed, or even the possibility of reappointment. You don't want them worrying about the possibility of getting a cushy job in the private sector or academia when their term runs out. You want them to never have to worry about what the public or anyone else thinks in their technical interpretation of the law. You also, under this view, presumably would want fewer appointments, because each appointment is necessarily going to involve political influence from the political branches, the president and the Congress, specifically the Senate, for confirmation. So in a world with life tenure, you're going to have mathematically, on average, fewer appointments than in a world with term limits, which are going to happen more often by definition. That's why you have them, right? Which means fewer opportunities for politicians to influence what this sort of priestly class of technicians on the court is doing. Because in a formalist world, why would you ever want the views of society to factor in? In the formalist world, justices are more like heart surgeons or like really skilled mechanics. It doesn't matter what the people think, doesn't matter what the people want. All that matters is doing the best job possible, interpreting these complex sets of laws and regulations and legal principles and fitting them all together like this sort of complex machine. That, according to a legal formalist, is what the Supreme Court and all courts exist to do. So as Richard Posner explained in 1986, and Richard Posner, by the way, one of the preeminent legal scholars, he's both an appellate judge and a law professor at the University of Chicago, so his opinion does carry merit. And we're going to link to a really good article from him on legal formalism and legal realism. But what he says in defining formalism is this. He says, formalism enables a commentator to pronounce the outcome of the case as being correct or incorrect in approximately the same way that the solution to a mathematical problem can be pronounced correct or incorrect. And as Posner goes on to note, a really important extension of this idea of objectivity and objectively correct outcomes is that legal formalists don't believe that it is appropriate to measure a court based on whether its decisions produce social benefits. Whether they produce social benefits don't matter. A utilitarian analysis like, did the court make life better for women, or did the court make elections more fair, isn't appropriate, because that's not the technician court's job.
The court's job to a formalist is basically to solve these complex legal math problems or these puzzles or whatever by correctly discerning what policies and laws other people made and how those policies and laws interact. So if the court looks at a harmful law that Congress passed or a harmful provision the framers wrote into the Constitution and says, yes, this is harmful, but it's what they're meant to do, so we're upholding it, in a formalist world, the court has done its job perfectly, and it's reached the objectively right result. And if you don't like that result, a formalist would say, have Congress repeal the statute. Have, Congress amend the Constitution. The Supreme Court's job is simply to say what the law is, not what it ought to be. So in other words, there is an entire school of thought out there under which debaters cannot legitimately access practical utilitarian impacts, like curtailing voting rights is bad or upholding free speech is good, and must instead look solely to whether the court is accurate in its legal interpretations, because the court, under a realist approach, is not meant to be a policy-making body.
So the problem, as legal scholars have been pointing out for at least a century now, is that this view of legal realism is incredibly naive. The idea that the Supreme Court doesn't make policy is very clearly just not true, or at least not absolutely true. It may have some influence on what they do, but it is counterbalanced by a very heavy dose of reality. And that dose of reality, that more pragmatic view, is what we call legal realism as opposed to legal formalism. Legal realism basically says that we need to view the Supreme Court, and really all courts and really all government, through a more realistic lens of what they actually do and who they actually serve, as opposed to just their formal role under the Constitution. Legal realists say, look, there's a reason why every time a Supreme Court position comes open, you have a huge political fight over the newly appointed justice. It's not, I promise you, because Republicans and Democrats in Congress care deeply about the legal acumen or scholarly ability of these Harvard and Yale Law School graduates. It's because they know, and we know, that the Supreme Court is making policy, and the President and the Senate want justices on the bench who will make and uphold policies that line up with their views. So there's a very good summary of this from Gibson and Caldera in 2011. As you can see here, what it says is, Americans today live in an era in which nearly all observers of the legal process acknowledge the key role of ideology and political values in the decision-making of the U.S. Supreme Court justices. As two of the most prominent analysts of the Supreme Court observed, simply put, Rehnquist votes the way he does because he's extremely conservative. Marshall voted the way he did because he was extremely liberal. Even if some debate exists about the degree to which policy choices of justices are constrained by legal and extra-legal factors, no serious analyst would today contend that the decisions of the justices of the Supreme Court are independent of the personal ideologies of the judges. In this sense, legal realism has carried the day. Indeed, as Packer and others have put it, we are all realists now. And as somebody has been to one of these name-brand law schools and has been an appellate lawyer for a considerable part of his career before I came to Mississippi State, I can tell you this is true. Legal realism has won the battle in academia, and it is the way that most people view the court today. It's
so pervasive that it's basically reported now as fact.
Right.
Take a look at this excerpt from an article published literally today on a more or less random SCOTUS case in The Hill. They reference Justice Ketanji Brown Jackson as a liberal justice, quoting her saying, "I guess I'm thoroughly confused." They go on to say conservative Justice Clarence Thomas, the only justice to have previously expressed doubts about the breadth of Section 230, blah, 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 blah. And then they go on to reference liberal Justice Elena Kagan. So obviously we can see news outlets just as a matter of fact dispense the idea of,
You were doing good.
So as we can see here, news outlets just matter-of-factly dispense with the idea of impartiality and label Brown Jackson and Kagan as liberal justices and Thomas as a conservative justice. Now, it's not to say that every single vote by every single justice is a raw political act. Like, we know that Gorsuch doesn't always vote conservative, and Sotomayor doesn't always vote liberal. There are plenty of cases where the correct legal result is clear, and there's not much room for ideology. And in those cases, and we'll talk about this at length later, the Supreme Court tends to see a lot of consensus. There's plenty of 8-1s, 9-0 cases where the reasoning in the opinion isn't really ideological or political at all. So in cases about whether, say, the Department of Health and Human Services can lower a certain type of Medicare reimbursement rate without statutory authority, you'll often see a Republican appointee writing the opinion and all the other justices unanimously concurring. They basically decided there's no room for ideology or interpretation here. The result is obvious regardless of politics.
But in cases where you have a political hot button issue come up, like abortion, like voting rights, like redistricting, like money in politics, and so on. Not surprisingly, in those cases, the justices overwhelmingly do find, what do you know? There is room for interpretation. And their political ideologies overwhelmingly do make their way into their decisions. To put it bluntly, Republicans did not put an extremely conservative, Catholic judge like Amy Coney Barrett on the court so that she could turn around and decide, you know what, I actually think that Roe versus Wade was correctly decided. I'm going to vote to uphold it. No, these judges and later justices, right, were chosen from a pool of admittedly very smart and accomplished lawyers. No one's denying that Amy Coney Barrett is not an extremely accomplished and skilled lawyer and judge. But within that pool of accomplished people who could be on the court, they are selected by their respective parties based on their commitment to conservative or liberal/progressive views about what the law says. And when these judges and justices interpret the law, they are also making the law, right? We have this distinction that we learn about, again, in high school civics, like, well, one branch makes the law, the other branch interprets it. No, when you interpret the law, you are also making new law. There is no fundamental difference between judicial interpretation and policy making under the legal realist framework. And so when the Supreme Court rules in a case like Shelby versus Holder back in 2013 that the Voting Rights Act of 1965 can no longer require these formerly segregated states to get pre-approval of their voting laws from the Department of Justice, they are deciding as a matter of policy that yes, there are going to be more restrictive voting laws in southern states. They will be implemented, and that is, we have to call it what it is. That's policy making.
And to a legal realist, if the court is engaged in policy making, we should just own up to that fact and implement the same kinds of controls on the court that we implement on other policymakers. We should not treat them as life-tenured priests insulated from the concerns of politics because they manifestly are not separated from those concerns at all. Instead, we should impose limits and constraints similar to those that we put on other policymakers. And of course, one such limitation could be term limits. Term limits would mean that we would appoint justices more often, of course, which would mean that the court would be held accountable to the political branches of government more frequently. And to a legal realist, that's generally a good thing, although it could certainly get hijacked by structural problems in the other branches. But generally, we want the people to have more of a say in what the court does, at least according to a legal realist. Term limits, and we'll talk a little bit about this later, but would also mean more representation on the court, at least over the long term. More different justices means more people from different backgrounds with different careers and different experiences shaping our laws, which if we're talking about policy making to a legal realist is a very good thing.
So anyway, very long story short, while we're not going to lay out like specific theories and tell you exactly what to use for your criterion or your value, I do think it's really important for all debaters in framing the theory underlying this resolution to think about the core theory about what the court's most basic job is. Is it A, calling balls and strikes like an umpire, as a legal formalist would argue, or B, basically high-level policy making, as legal realists would argue? And look, I'm not going to lie to you. Like we said earlier, there's no question that legal realism is the overwhelming consensus among scholars today and among society generally. If you ask just a regular person on the street, do you think Supreme Court justices are completely impartial, they'll laugh at you and say, no, of course they're not, right? But the point is, if that's the view you're taking, you want to be conscious of it. You want to know what you're arguing. You want to understand that is the theory behind what you're saying on either side of the resolution. You want to be saying to the judge in very clear terms, look, in the real world, we know that the Supreme Court is making policy. We know that they're making value decisions and policy decisions. So we should want people who make those laws to be more constrained and more representative of the people that they're governing, just like the other branches, right? So anyway, that is the very high-level philosophical analysis. So now let us move on and talk about some AF arguments followed by some neg arguments.
Let's jump right into some AF arguments, the first of which is that life tenure gives unprecedented power to our justices and is out of step with the real world. So the power that we give our justices in the form of lifetime appointments is the outlier. It's not consistent with what most of the rest of the developed world does. Most of the world imposes term limits on judges, including judges on their respective Supreme Courts. So some examples are outlined by Rosalind Dixon, a guest columnist and law professor writing for the New York Times in December of 2021. She says, quote, judicial term limits are a tool widely employed by constitutional designers around the world. Some countries follow the British model of judicial age limits, Others follow the German model of fixed judicial terms, but almost all, other than the United States, reject the idea of lifetime judicial tenure. And I'm not going to read all of it, but she goes on to give a couple of examples, like Germany and South Africa that have 12-year terms, Colombia and Taiwan that have 8-year terms. So as we can see, most of the developed world has at least some form of a term limit or an age limit, and the power that we give our justices is simply unprecedented. And to be clear, those governments that have term limits for their judicial appointments are some of the most globally respected. That Dixon article goes on to say, perhaps most importantly, countries with strict judicial term limits include some of the most powerful and respected constitutional courts in the world.
So this aberration that we have in our system, this unusual status, is not even new. It's something that was understood when the Constitution was ratified. So there's this thing called the Anti-Federalist Papers. You've probably heard of the Federalist Papers. These were a response to the Federalist Papers. It included a passage by a pseudonym, I don't know how you say it's like anonymous but with a pseudonym. You know the word I'm talking about, right? Anyway, this person was writing someone named Brutus, as you can see. And what you see here, we'll just pop it up on the screen, but you can see, people who were prominent in the debates around the time of the framing are saying that, look, this transcends any power before given to a judge by any free government under heaven. And that's true. The idea of a lifetime appointment with no accountability, with no tribunal that can sort of call them out for misconduct or anything like that was a new thing.
Also worth noting is that the need for judicial term limits is something that the states understand and recognize. As Michael Hiltzik noted in 2022 in the Los Angeles Times, life tenure for judges sets the federal government apart from the states, only one of which, being Rhode Island, grants its Supreme Court judges life tenure. In all other states, the high judges either have fixed terms or are required to step down at age 70. Now, I probably wouldn't devote an entire contention to the U.S. being an outlier, but I do think it's definitely worth at least mentioning in the AF case somewhere, because it starts to tear down this idea in the judge's mind that life tenure is somehow sacrosanct,
right,
or that changing it would be this radical departure from the norms of how a Supreme Court is supposed to work. It's not a radical departure at all. The status quo is. And briefly letting the judge know that at the start of your case is a pretty smart way to set the tone for the rest of the round.
So on a somewhat related point, when Article 3 was drafted, people lived much shorter lives than they do now. And so the argument would be that life tenure wasn't designed for longer life expectancies. As a practical matter, term limits in the 1780s were imposed by the reality of lifespans at the time. That limitation has been significantly eroded in the more than 2 centuries since, so the AF would argue it's time to sort of reinstate it by a change in the law. This is from that same piece by Michael Hiltzik in the Los Angeles Times in 2022, and it just notes the average tenure on the court was 15 years until the 1970s, which we mentioned earlier, when it shot up to 26 years, and by 2005, the average age of justices at death or resignation was 79, which is a record. And again, as we noted in the background section, this issue is only going to get more pronounced with the average tenure on the court expected to rise to 35 years within this century. So this just further reinforces the idea that the status quo of life tenure is not something that was literally handed down, by God. It's something that's out of step with reality, and it further normalizes this idea that we need to do something to change it.
And this is again somewhat related, and that's our next argument, that term limits would reduce the risk of judges with mental decline. So this argument just posits that people of older ages sometimes experience mental decline as they age. Now, obviously this is an argument you have to be extremely careful and diplomatic with. If you're cavalier about this, you're going to run the risk of conveying age bias, which is not a good look if you're some 16-year-old know-it-all. So buyer beware here. But it is an issue that absolutely comes up in the mainstream literature on term limits, and there have been justices in the past who were urged to continue serving for political reasons when they were experiencing some serious declines in reasoning. So an example again comes from Michael Hiltzik that we mentioned earlier in the LA Times in 2022. He writes, the prospect of open-ended service on the court encouraged justices themselves to try gaming their retirements. Typically, they tried to hang on until they could be assured that a like-minded president would appoint their successor. And then he goes on to give the example of William O. Douglas, whose 1974 stroke left him so debilitated that his colleagues on the bench secretly agreed to hold over any cases on which Douglas would cast the deciding vote to break a 4-4 tie. He ended up retiring in 1975 and died in 1980 at age 81.
So the AF argument here would basically be that the current nomination process basically traps justices who would probably rather retire and really need to retire from the perspective of what their faculties are in their position, hanging on out of fear that an antagonistic president will nominate their successor and essentially flip the seat, right? Now, to be fair, there are plenty of counterexamples here. So, for example, Justice Ginsberg died in office when it was pretty widely known that she wanted to retire as soon as a Democrat was elected president. And I don't think there's anybody who reads Ginsburg's opinions who would argue that she wasn't sharp as a tack right up to the end. But even there's almost, I would say, like a humanitarian argument that after somebody has worked for 20 or 30 years, you shouldn't be forced to literally die in office. Like, you shouldn't be forced to literally work until you die due to a broken nomination system.
Right. Another variation on the idea that term limits are really mainstream is the argument that term limits are popular. So as we've been over already, and as we'll discuss again at length later, the Supreme Court doesn't have any real enforcement mechanism. Really, its only hope is legitimacy. And at a time where American faith in the court is at all-time lows, which again we're going to talk about, reforming the court in a way that's intensely popular can be a step towards restoring that legitimacy in the minds of the American people. So fortunately, term limits are massively popular. This comes from NPR in July of 2022. They cite a poll done by the AP in 2022 that found that 67% of Americans support judicial term limits, including 82% of Democrats and 57% of Republicans. Now, I mean, let's be honest, in an age where we can't even agree about what's up is up and what's down is down, having bipartisan support for anything is pretty remarkable.
We do agree on shooting down balloons. We like to shoot down balloons, and we like judicial term limits, but that's about it.
Those are your two. This is also confirmed in another poll by the Morning Consult and Politico in May of 2022. They found the exact same number, that 67% of respondents supported term limits and only 18% cited that they disapprove.
In addition to this public support, Supreme Court justices have themselves expressed support for it. So, for example, this is from a YouTube video with Stephen Breyer, former U.S. Supreme Court Justice, talking to the Association of American Law Schools, and he's quoted as saying, "I do think that if there were a long term, I don't know, 18, 20 years, something like that, and it was fixed, I would say that was fine. In fact, it would make my life a lot simpler, to tell you the truth." Justice Breyer was kind of known as being a guy who wasn't like super hardcore about things and probably would have rather gone home. Also, as we talked about earlier, Chief Justice Roberts has gone on the record saying that term limits are an idea that merits serious consideration. So anyway, having firmly placed term limits in the realm of acceptable, normal, popular ideas, which is something you're going to want to do as the app. It's not a radical proposal. If anything, this is mainstreaming our laws. It's not making them more radical. Let us then turn to a more substantive argument, which is that term limits address the political legitimacy crisis that the court is facing. So this argument hinges on the idea that the American people should trust the courts and generally support them. An institution's legitimacy, when we use that term in politics, is just the idea that most people generally agree that the institution is performing its proper function, in the case of government entities, acting according to the public interest. Legitimacy is important for all branches of government, but it is especially important for the judiciary. In fact, legitimacy is really all the judicial branch really has. The president, in addition to many, many other things, commands the army and the armed forces, right? The Congress controls the Treasury. They have all the money. What does the Supreme Court have to back it up when it tells those branches, or it tells the states, or it tells powerful corporations that they can't do what they want to do? Well, there's no army for the Supreme Court. There's no Treasury. There is only the court's legitimacy. The idea that the American people will demand that the court's decisions be followed and will oppose and punish anyone who doesn't follow them. When that goes away, the Supreme Court becomes irrelevant, and democracy starts to transform into mob rule.
And by the way, please don't think that those threats to the Supreme Court are just hypothetical or academic. They are absolutely not. So, for example, J.D. Vance, the newly elected Republican senator from Ohio, publicly stated that Donald Trump should have just summarily fired many federal employees in violation of the law and then dared the Supreme Court to do anything about it. So in other words, Senator Vance said Trump should seize power he knows he doesn't have, which arguably is treason, but Republicans. and bet that the Supreme Court would lack the legitimacy to stop it. And this is just one example. If you look back through the records surrounding the 2020 election and January 6th, you'll find countless Republican officials basically arguing that the court would be too weak, it would lack the legitimacy to stop a full-on attempt at a government coup. So Supreme Court legitimacy is obviously extremely important, and there's plenty of evidence that it's declining.
In terms of that evidence, very generally, the Supreme Court's approval rating is reaching historic lows. As you can see from the graphic we have here from Gallup, you can just sort of see only 47% of Americans say they have, quote, a great deal or even a fair amount of trust in the judicial branch. This constitutes a 20% drop in trust over just the last 2 years and is the lowest level of confidence of all time in the Gallup poll, as long as they've been conducting this particular poll. Maybe more importantly, confidence in the Supreme Court has shrunk to historic lows, with only 25% of Americans answering that they have confidence, as you can see from the graphic that we have here in this next slide. And to make matters worse for SCOTUS, people recognize an ideological slant when they see it. So as you can see in this chart, we see that a record high number of Americans believe that the court is too conservative. So it is not looking good for Supreme Court legitimacy. The question is, how do term limits address the crisis of legitimacy?
The basic argument seems to be that, first, if retirements and appointments become a regular, recurring thing, that has the potential to lower the stakes and the political fervor, and thus make the court seem less politicized to regular Americans. And second, if justices can't stay forever, they may be less likely to retreat in sort of a disconnected ideological bubble and instead remain connected to the real world in which people actually live. So Norman Eason and Sasha Matsuki, sorry if I butchered that, from the Brookings Institution in 2022, they sum it up pretty well. They say tenure limits are a robust alternative. They ensure a cyclical and predictable turnover. This would allow for new minds to join regularly and ensure one president or party does not have an outsized influence on the court and trajectory of constitutional review for decades to come, with each president likely being able to appoint a justice at least once or twice during his or her term in the White House. An increase in turnover would also mean justices are less insulated from everyday life and more in touch with the direction of legal analysis on particularly contentious issues. In addition, there's also a more specific argument that this current court specifically is uniquely illegitimate because of who appointed its justices, and that any policy that clears these justices out and replaces them is likely to result in a net increase in legitimacy. So this is explained by Hank Johnson, the U.S. Representative for Georgia's 4th District, in July of 2022. He says, quote, "This Supreme Court is increasingly facing a legitimacy crisis. 5 of the 6 conservative justices on the bench were appointed by presidents who lost the popular vote, and they are now racing to impose their out-of-touch agenda on the American people who do not want it."
I'll be honest with you. I do think that the link on this argument about legitimacy is maybe a little weak. But it's an argument that a lot of people are talking about in the literature, so we wanted to make sure we give it its due. Specifically, and we'll talk about this on the neg, I'm not sure I buy that regular recurring 2-year appointments would somehow be less political, right? We elect the entire House of Representatives every 2 years on a regular cycle. I don't think anyone would say that that's apolitical. I do, though, think that the second argument, that the current court is more illegitimate, right, because it was appointed by presidents who lost the popular vote, does have a little bit more traction. You could argue that really, going forward, on average, presidents who won the popular vote are probably going to be appointing most of the justices because they will hopefully tend to win elections, so it can only get more legitimate. So this might have a little bit more traction, for example, in a circuit where your judges lean progressive. And by the way, as you could probably tell from our little Republican joke a second ago, we have our biases here. I mean, we as individuals, but we acknowledge them. And you have to be aware of those as you're debating, and you have to be mindful of where your judges are coming from and what their biases are as well, and sort of plan your arguments around that. But at any rate.
Right. So to keep us moving, on a related point, there's also the argument that term limits would reduce the impact of random luck. Now, the basic idea here is that the composition of the court is largely up to just dumb luck as to when the justices retire or when they die, or whether they just fall just before or after elections. So this is explained again by Michael Hiltzik in 2022. He says, as pointed out by Erwin
Chemerinsky. He's kind of a celebrity. He did my bar, when I studied for the bar exam, I listened to him talk for like 19 hours. So kind of a star.
All right, so those are his credentials.
Right.
Erwin Chemerinsky. He points out that Republicans held the White House for 32 years and Democrats for 29, which is almost an even split from 1960 through 2021. But in that period, Republicans appointed 15 justices and Democrats appointed only 9. And he goes on to talk about specific justices like Neil Gorsuch and Amy Coney Barrett, who benefited from literally just luck and political maneuvering. So the current nomination structure means that whether a given party party gets to make a nomination is left up to mere chance. And Republicans have just so happened to get lucky and have justices die or step down during their administrations, whereas Democrats haven't gotten so lucky.
Right, and the argument here would just be that SCOTUS is making critical policies that affect people's lives. It's part of our democratic policy-making process, that legal realist view again, right? We don't want to leave these outcomes of that process up to like random dice rolls about when various elderly people will happen to succumb to a certain illness or feel that they need to retire. We want it to reflect as closely as possible, with as little randomness as possible, the actual will and the actual preferences that voters express. And a system of 18-year terms with 2 appointments per presidential administration would do just that. The stakes would be exactly the same every election cycle. People would know who's coming up for replacement, and they could plan their votes for president and for Congress accordingly. That is just a more fair, more democratic way to do things, regardless of which set of policies you prefer, regardless of sort of which party you support.
That leads us to our next argument, and that is that term limits produce simply better overall judicial candidates. So this is basically premised upon the idea that whenever a president chooses a nominee to fill a vacant seat on the Supreme Court, they have to balance a lot of factors. They have to balance their confirmability, their intelligence, their legal experience, their ideology, their age, and their constituent desires. And the status quo has created a state of affairs in which presidents almost always default to sacrificing those other things to basically privilege age and choose a candidate who is very, very young. And that's because, as we pointed out, the status quo creates a set of perverse incentives. Rather than nominating the most qualified candidate, the argument goes at least, presidents nominate the youngest judges who have a lengthy term ahead of them. Limiting terms obviously takes away this perverse incentive. You can nominate the most qualified candidate without having to think about if they'll be able to stay alive for several decades. So this is discussed a bit by the Calvin Coolidge Foundation in May of 2021. They cite legal scholar Kermit Roosevelt of the University of Pennsylvania, who explains that under the life tenure system, age very routinely gets in the way of choosing the best candidate. They go on to say, with respect to the justices themselves, the current system gives presidents incentive to pick a younger nominee rather than the best qualified to maximize the length of their influence on the court. Older candidates, no matter their status or abilities, may be eliminated for reasons of age alone. So obviously we see a system of term limits would give all justices the same amount of time to serve, and it would eliminate those distractions, it would eliminate those perverse incentives about age that make our Supreme Court made up of people, at least as this argument goes, who are less than qualified. So this, not only does this perverse incentive structure mean that the quality of our nominees is sacrificed, it also contributes to that perception of partisanship by the American people that we talked about as happening on the court. Now, this is explained in what I think is a really great article that you should probably read called What's Age Got to Do with It by Jonathan Katz and Matthew Spitzer. They do basically a study about the influence of age on the court, what it means for the partisanship of the court, and how term limits could solve that problem. And these authors find that for the past 40 years, Republicans have appointed, on average, younger justices than Democrats have. And that this average age difference has certainly contributed to the rightward shift of the court over time. And they further find that if this trend continues unchecked, if we don't have term limits, this rightward ideological shift will certainly continue. Now, of course, a consistent shift in the political ideology of the Supreme Court is not very much going to help the American suspicion that the court is a politically partisan institution. So preventing that trend from continuing would probably be in the best interest of the court and of the American people. But the paper gets even better. The authors go on to conjure up a computer simulation that honestly goes way over my head and is probably why you should read the article. So you
Well, we both majored in political science.
Exactly.
Like we don't know how this stuff works.
Right. But basically, they find that if 18-year term limits were imposed, the ideological effects of having one party consistently appoint younger justices would be almost completely wiped out, because obviously the incentive to appoint younger justices goes away and they would eventually term out and go away. So you can see that on this handy chart where they find that the difference in median ideology, which they measure by ideal points, is pretty substantial whenever 18-year term limits are imposed, with a pretty drastic shift to the middle. So term limits seem like a pretty huge step in, first, producing more qualified candidates by taking away that perverse incentive to choose young people, and two, by mitigating the intense partisanship of the court.
And also, this is one of the very, very few sort of precious pieces of sort of empirical evidence you can actually bring to bear on this topic, rather than have to sort of just purely do storytelling. So that's pretty cool too. So the last argument I have on the AF is enhancing representation and diversity. So if you don't know, my day job here at Mississippi State is being the Director of Civil Rights Compliance, so this is something that's important to me. But basically, the faster we turn over justices, the more appointments we do, the sooner we're going to get more people of different backgrounds on the court. I'm not going to cite a source on this. I might try to find some. I didn't see any initially, but it's really just a common sense point, right? If you look until very recently in our history, the court was comprised entirely of white males and then just of males, right? And then overwhelmingly of white males and just a few exceptions, people like Sandra Day O'Connor and then later, Clarence Thomas and people like that. But overwhelmingly, it is not representative of the demographics that actually make up this country, right? And so if you are a legal realist and you believe that those perspectives matter, right? That, for example, I don't know, women's perspectives matter on whether we're going to repeal the right to abortion. I know, crazy ideas like that, right? But if you believe that that is important, we're never going to have it be as representative as, say, the House of Representatives, because there's only 9 people. But the more people we have coming on and off, the more different groups in American society get their say. So, for example, judges with different sexual orientations, trans folks. Another one that just occurred to me while you were talking is disabled folks. I mean, if the bias is in favor, and I'm just thinking here out loud, but if the bias is in favor of people we know are going to be on the court for decades, there would be a huge built-in bias against anybody with a medical condition or a health condition that might limit their ability to serve into their 80s. So right there by itself, you'd have an increase in representation and diversity. But anyway, the bottom line here is that the more turnover we have, right, the more appointments we make, the faster we get to a world where more representative folks have a say on the court, and if they are making policy, we should want them to do that. So that's what we've got on the AF. We will come back in just a second and talk a little bit about arguments on the negative.
It's about time we jump into some negative arguments. So we'll begin with the first, and that is that the court really isn't all that partisan or divided.
Right.
So kind of like we did with the AF, talking about how life tenure isn't normal or sacred, I think it's also important to set the tone on the neg by dispelling one of the most common myths about the Supreme Court and assumptions that are used to justify term limits and other changes to the court. So like we said earlier, many AF debaters are definitely going to make this argument that the Supreme Court is facing some partisan crisis in which justices take advantage of their lifetime tenure to advance some political agenda. And while there are definitely some instances of that intense partisanship that dominate the headlines and make SCOTUS basically seem like a mini Congress, this narrative just really doesn't hold up. And I think as the negative, you're going to have to make this compelling narrative to your judge. Like, if you're going to disrupt this institution that's existed for centuries, you need to have a pretty darn good reason to do it. Right. And if this problem is non-existent, then it's going to be really difficult to vote in the AF. So this is explained in what I think was an exceptional article in 2018 by Sarah Tuberville and Anthony Markham in the Washington Post. And they cite the Supreme Court database that found that since 2000, a unanimous decision has been more likely than any other result for the Supreme Court, averaging 36% of all decisions. That doesn't sound like a lot, but it's a plurality compared to the others. And even when the court did not reach a unanimous judgment, the justices often secured overwhelming majorities, with 7-2 or 1-2 judgments making up about 15% of their decisions. And 5-4 decisions, by comparison, occurred in 19% of cases. And they go on to say that the court's commitment to that consensus does not appear to be slowing. In the 2016-17 term, 57% of their decisions were unanimous, and judgments with slim majorities, 5-3 or 5-4, accounted for, or 6-3 and 5-4, accounted for 14%. Now, that Washington Post article is pretty old. It was written in 2018, but this unanimity seems to be the case today too. So there's another article written by Devin Dwyer in ABC in 2021. And he found that 2021 constituted the year with more unanimous opinions by the court than any other time in the last 7 years. An analysis by ABC found that 67% of the cases argued during that term were decided unanimously or near unanimously, with just one justice dissenting. And Dwyer attributes much of that consensus to Mr. Chief Justice himself, John Roberts. John Roberts has touted ever since becoming chief that his goal as Chief Justice has been to promote consensus across ideological lines and protect the image of the Supreme Court in the public's eye. That's just the kind of Chief Justice that he is and that he has always been.
Or that he's been trying to be, at least. He's
right.
got some headwinds definitely there. But ultimately, while the public might believe that the Supreme Court is driven solely by politics, the answer is they're just wrong, right? There are, as Mia said, some very high-profile cases, obviously the reversal of Roe and things like that, and real problems do exist within the Supreme Court, but this narrative is false. This isn't one of them, and we're solving an imaginary problem sort of for the public's appeasement, and that's not a good use of time and not a good use of policy. So with that important myth dispelled, let's turn to sort of the offense for the neg, the more overt offense, starting with term limits increase the likelihood of political or outside influence. And look, this is pretty straightforward. We alluded to it earlier. If you know that you're either A, going to get reappointed by Congress, like by the President and by the Senate, or B, you're going to have to find work outside of the government when your term ends, you are far more likely to consider the views of politicians, corporations, and other elites rather than doing what you subjectively believe is legally correct. So this again comes from that piece by the President's Commission on the Supreme Court in 2021, and we'll flash it up there on the screen, but as you can see it says a more specific concern relating to judicial independence involves what justices would do after their terms expire, and whether their plans for the future might affect either their performance as justices or public perceptions of that performance. One might worry that a justice who is eyeing future positions in government might try to curry favor with political constituencies, or that a justice who is eyeing future positions in industry might decide cases in light of those plans. And it goes on, and you can sort of see all of the things that it says. I would say that this argument, by the way, gets considerably stronger if AF is running anything but a single non-renewable term, right? So if SCOTUS justices have the ability to be reappointed, then concerns about them currying favor from like outside sources go from being like these abstract worries about maybe like looking for a cushy job or something along those lines to becoming these direct concrete issues of like trying to please the current Congress or trying to please a future president or something like that and the party in power, which is why, by the way, I think it is extremely risky and a bad idea for the AF to advocate for anything but a single non-renewable term.
Ultimately, this is just a common sense argument that's rooted in the exact same justifications for life tenure that were around whenever the Constitution was ratified. If someone knows they're going to be in the public eye for about 18 years and will need something to do after that, they are more likely than in the status quo to keep their eye on public opinion. And regardless of whether you're a judicial formalist or a realist, both schools agree that public opinion is not how you should decide cases. One side says follow the actual letter of the law. The other side says that you should do justice in individual cases depending on those facts, but both sides agree that you should not be worried about how your decision is polling because you want to run for office or be a dean of a law school when your term is up.
So the next point that we have for the neg is that term limits actually increase politicization and polarization. This is a pretty direct response to the AF argument that term limits will reduce polarization. And here what we have is the neg saying, no, it's just the opposite, they're going to increase it. So the basic argument is, look, how can you possibly believe that a plan to explicitly tie Supreme Court vacancies to every single presidential election, with every president getting exactly 2, that's the consensus 18-year approach, will somehow depoliticize this process? So this is from Anthony Markham, fellow at the R Street Institute in 2020. And what he says is that although well-intentioned, term limits have a problem. Not only are they unconstitutional, but they will have the exact opposite result proponents wish for. Term limits will ensure that court vacancies are inextricably tied to every presidential race and have the potential to create abrupt ideological shifts on the highest court, only increasing the political scrutiny. In other words, term limits will not lower the temperature around nominations, they will leave the country scorched. If anything, the consensus 18-year plan would have the opposite effect of depoliticizing. People will start to view the 2 Supreme Court justices that every president gets to appoint as essentially like part of a package deal that they are voting for in a presidential election, almost like part of the ticket, potentially, almost like the vice president.
Right. If term limits are implemented and presidents are guaranteed 2 appointments, does anybody doubt that presidential candidates will just announce in advance, these are the 2 people I'm going to be nominating for SCOTUS if I'm elected?
Right.
I mean, as Brett said, this effectively expands the ticket to reach out into additional constituencies, again, sort of like the vice president. And frankly, I think the negative has the stronger argument on the politicization and depoliticization argument here. Term limits are basically an admission that the Supreme Court is political and an attempt to work around that. So it's really tough to understand how it then makes it less politicized or polarized. And this isn't just an argument that we came up with. The President's Commission on the Supreme Court made a similar point in 2021, which we're not going to read, but we will pop on the screen. And as you can see, the argument is that when you make nominees explicitly part of a Republican or Democrat administration, it's hard to see how that can possibly make them any less political.
Right, and this can act as sort of a turn on any argument that justices use their positions to advance politics. If it really is the case that justices are no more than partisan ideologues, they will have no choice but to act in an even more explicitly partisan manner under a term limits proposal. So it's sort of like if I'm a supervillain tasked with destroying a city, but I'm given like 100 years to destroy it, I might make little changes here and there. But if I've got 5 years to do it, well, I'm going to have to move much more quickly and be much more disruptive. So if you know that you're a Republican or you know that you're a Democrat and you know you have a fixed amount of time to accomplish what is, at least people perceive as being sort of your mission, right? And I realize that's kind of a cynical view. You're going to have to act much more radically and make changes much more quickly than you would otherwise. And that leads to the next argument on the queue, which is term limits destabilize the court and the law. So one of the key features you want in your legal system is stability. This is something we get taught a lot about in law school, particularly like in contracts class, about like predictability and things like that. You want your courts to reach the right result, yes, but you also want them to not keep changing the rules on people. That's almost as important as reaching the right result. So stability and predictability are essential for a democratic society because they let people and businesses and other institutions structure their decisions and conduct, being more or less sure what the legal result will be.
So for example, if we want corporations to locate jobs in the U.S., they need to have some reasonable assurance that the corporate tax code isn't going to suddenly change overnight. Or if we want people to move between states to go to school or find work, we'd like them to be reasonably sure that their basic constitutional rights are not going to disappear in some states, like for example with the recent overruling of Roe that we've mentioned many times that led many states to essentially ban abortion.
Right.
So the next argument here then is that term limits inevitably lead to more turnover on the court, and the more change you see of the composition of the court in a politically polarized world, the more you see the fundamental legal principles shifting back and forth, which reduces stability and predictability.
The best piece that I've seen on this comes from Susanna Sherry, who is a Vanderbilt law professor in 2019, on sort of the general risks of Supreme Court term limits. I'm going to read a little bit here. This is a great piece. This is similar to the one Mia looked at earlier because it gives us something like a little bit of empirical evidence, right? So what it says is a Supreme Court that welcomes a new justice every 2 years and turns over entirely over the course of every 18 years could wreak havoc on doctrinal stability, in other words, the stability of the rules and the laws that the court recognizes. Under the current constitutionally mandated system of life tenure, the court changes slowly. A constantly changing court, on the other hand, might make sudden and radical changes in doctrine. And what she says is that she and her colleagues actually did something that's fairly rare for law professors, but she also used a computer simulation. In this case, to model what is likely to have happened to abortion rights after 1973 when Roe v. Wade was decided if term limits had been in place from then until now. And what did we find? Roe suffered whiplash. Positing moderately loyal justices with no deference to precedent, Roe would have been overruled in 1987, reinstated in 2009, and overruled again in 2017. In the end, then, term limits are likely to have a substantial detrimental effect on doctrinal stability. In other words, the predictability and the reliability of the law that people can count on in making their plans. A case could go from being a sure winner to a sure loser over the course of a single election, and that doctrinal instability would likely alter the nature of jurisprudential evolution and change the focus of litigants, policymakers, and lower court judges from doctrine to the court's composition, further politicizing the court. So this is a nifty piece of kind of sort of empirical evidence, which is pretty rare, as we said earlier. Granted, this was probably a lot more impactful before the Supreme Court actually came along in the status quo and reversed Roe, but still, the piece has it shifting back and forth 3 times, which supports the larger point that instability will increase in a world with term limits.
You can tell a really powerful story here about how bad actors could try to use their time on the court or use their litigation to get the result that they want while a temporary favorable majority is in place. And again, you see this very argument reflected in the President's Commission report from 2021. They say, they just give some examples of political gamesmanship that the court might have to engage in. I'll give you some of the examples they cite. They say, if it's known that a swing justice will lose the power to participate in cases on a specific date, litigants or lower courts judges might try to time the case accordingly, or they say that they might accept cases before they've even been able to fully percolate through the lower courts, or they might take up or accept a case that is not the ideal vehicle for presenting or deciding this particular question, just so they can do it whenever they might have a swing justice on the court or at the ideal time for their ideology. And this kind of legal game playing is not just bad for policy outcomes, it also wrecks legitimacy, as the Sherry article that Brett was just reading points out. Because people no longer have any illusion that this is the unchanging law of the land, but rather this is what the law is when Republicans appoint a couple of justices, and this is what the law is whenever Democrats appoint a couple of justices, and it's all transparently political.
So last but not least on the negative, I have an argument which is that this sort of opens the door to further political meddling with the court. I would definitely put this in the sort of experimental / squirrel argument category, but I do think it's one that has some real potential if you commit to it, if you do the research on it. And it's the idea that once you open up the Pandora's box of restructuring how the court works and how the membership of the court works, you really can't control what comes out of that. So again, looking back to the President's Commission on the Supreme Court, and just a great source that we keep coming back to, what they say is that a broader concern is less about term limits than about reform in general. In our current polarized environment, any change to the structure of the Supreme Court might be regarded with suspicion. In addition, one reform might open the door to further proposals for structural change with some risk to the stability of the institution. The idea here would be that while the Supreme Court does have a lot of problems right now, it could always be worse, right? That's the core tenet of like old school conservatism, real conservatism, which is, yes, it's not perfect, but it could be a lot worse and we need to be careful. And in particular, in an insanely polarized sort of post-Trump world where you have just yesterday, Congresswoman Marjorie Taylor Greene from Georgia going on Twitter and calling for red states to secede from the union because woke culture is so bad, right? And so on. It is possible for things to get much, much worse.
And so the argument is that if we sign on to the idea of term limits, that lends legitimacy to other proposals. The public in Congress are going to see, oh wow, we can literally just fundamentally rewrite the structure of the government. We can change some of the most basic variables and basic values in our system. And in a world where just 2 years ago, on January 6, 2021, we saw a very real effort by Republicans to throw out the electoral votes of a bunch of states based on a fringe interpretation of the Constitution, is now really the time that we want to open Pandora's box and start fiddling with the dials and the levers of how our government is structured? We'd say probably not.
Right. So anyway, in the interest of time, we're not going to play out all the scenarios on this because that would take a while. It could be fun, but we just don't have time to do it. But I think that there is a strong intuitive argument here that, like, if you like more real-world practical impact, if you just like sort of talking to judges about politics, it's just a huge risk to start down this road right now, given that the marginal impacts on the court are so small. And let's be real, as you heard throughout this entire video, I mean, we're not talking about like predictable saving a million lives or $1 billion or anything. It's just little fringe here. It might be a little better here. It might be a little worse. Their arguments. If those are really the scope of the impacts, the negative would say, Judge, you should err on the side of caution. Do not open up the emergency panel where we can play with the dials of how the government is structured when we have the government we currently have. Stick with the status quo and vote negative, right? So with that, that's all we got on the negative. We will come back in just 1 second with just a few final thoughts on the resolution.
So now that we've gone through all the substance, all the arguments, let's just wrap it up with some final thoughts. So first, I've got 2 things. First, there will definitely be some growing pains. And by that I mean that especially if you're in a technical circuit and you've been used to weighing impacts, linking everything to nuclear war, comparing studies, you're not going to be able to do that on this topic unless you're super skilled. I don't think I could link the Supreme Court to nuclear war, but maybe you can. I don't know.
Somebody's going to try.
My advice is that you should force yourself not to do that. I know it's going to be very frustrating, but the NSDA has given you an opportunity to grow as a different kind of debater. One that can look a regular person in the eyes and just tell a story that doesn't have to be screaming over numbers or screaming over which impact weighs more. You're just going to have to be persuasive. And we think that's good for you. I think it'll make you into a better debater. It'll be good for you, so don't resist it. Just go into your real life, tell this story to a real person who isn't involved in debate at all and see if it's coherent. Go look yourself in the mirror and see if you can tell this story in a logical way that seems persuasive without hinging on so many different studies and empirical pieces of evidence. And the second thing is a bit more substantive, I guess, and that's just if I'm on the affirmative, I want to make a really clear attempt to establish what the problem is with the Supreme Court in the status quo. Because if your opponents watch this video and they know that there's really not that much of a problem with division or partisanship in the grand scheme of things, you want to on the front end be able to establish what on earth is the problem. Because like I said, if we're creating what would amount to a seriously disruptive change to the institution, you better have a darn good reason to do that. So don't just prove that it's a good idea, prove that it's an idea that is warranted in the status quo.
Yeah, so what policy debaters would call the inherency argument. What's inherently wrong with the status quo such that we need to roll the dice on this? I agree.
Right.
My advice is very similar, so I'll keep it short. It's just that context matters, storytelling matters. As Mia said, you just can't bash people over the head with statistics. So you really do have to be able to tell a story from beginning to end. Here's what the court does. Here's why it's broken if you're on the app, right? Here's why the incentives change if we change this up, and here's why it matters. Also in rebuttals, your best bet, I think, in rebuttal, honestly, is to not really try to weigh impacts, but to really go after as often as possible, saying essentially their impacts will not happen. So for example, on polarization, it's hard to say how much polarization there's going to be, but if you're on the negative and you can just go in and attack and say, look, there's not going to be any decrease in polarization whatsoever. If anything, it's going to increase. I can't tell you exactly how much it's going to increase, but the idea that we would decrease it by making it overtly linked to a particular presidential campaign and you get exactly two, that's ridiculous. So essentially just trying to take out their impacts entirely probably is the safest course, because weighing is going to be very tough on this topic.
Right.
Again, we just don't have statistics to weigh. So with that, that is everything. It's an important topic. It's going to be for, again, state championships, national qualifiers, TOC, and things like that. So we wish you the best of luck, and we will close with the thing we say every time on this channel, which is debate is for everybody. So work hard, have fun, and hail state.